Number 23, Grady versus Chenango Valley.
Here's what I found.
Excuse me.
Alan Grady.
Good afternoon. May it please the court. My name is Robert O'Hare. I'm here with my colleague Andrew Levitt, and we're here on behalf of the plaintiff appellant, Mr. Kevin Grady. As set forth in our briefs, the judicially created primary assumption of risk doctrine is fundamentally incompatible with the express intent of the legislature when it adopted CPLR 1411, which abolished assumption of risk and contributory negligence.
And we've addressed that, right? I mean, we've said that basically the same thing, but this is a carve-out from that, a judicially created carve-out, but a carve-out.
That is correct, Your Honor, but I think it's time to revisit the reasoning of this court in that line of cases.
What's changed?
Well, I think what's changed is, as you can see in the, since the Turkett opinion, which I think that this court has gone exceptionally far to say it needs to be constrained, the doctrine that is, because there's been a tendency by the lower courts to try to expand the doctrine beyond what it was at least initially established to act as a defense.
So are you arguing that it's unworkable
Well-
because the lower courts can't properly apply it?
Well, we think it's unworkable and that we should just do as the legislature has intended, and that is determine whether the actors have conducted themselves under ordinary negligence standards.
If we were trying to pull it back to where you would say Turcotte had it, what would you do?
Well, I think that, and we think that Turcotte was improperly decided. We think that that was judicial rulemaking, essentially, judicial legislating.
I mean, Turcotte is a famous jockey who's at Belmont Park, who's injured in the course of a professional horse race, and you might see public policy reasons for somebody involved in professional sports who is a typical kind of accident in a horse race to say, we're just not going to allow that to proceed. But then I take it part of your argument, at least, is putting aside that you might want to throw the whole thing out. It's gone too far and now reaches into other sorts of things, and the appellate division has gone, you didn't say haywire, but, far afield.
Well, you are correct, Judge Wilson. I think that,
Where would you draw the line?
well,
So you have a horse jockey in a professional horse racing scenario here where you would assume liability issues and liability insurance is at one level, and then you have a local high school at another. So where would you draw the assumption of risk line?
well, as we said, our primary position here in the case is that it's just an overstepping of what the legislature intended when it enacted the statute back in 1975. But to Judge Wilson's point, that Turcotte case was really focused on a professional athlete, in that case, a professional jockey. And as you've seen since then, it's now...
But I don't think we would be that worried about allowing professional horse racing to survive in the face of liability, whereas it seems to me in cases like this one involving high school athletics, part of the policy reason for our doctrine is we want these programs to continue without the threat of crushing liability that would essentially end them. So why wouldn't it be more applicable to the high school amateur sport arena?
Well, as it relates to scholastic sports, I think there's a problem with having minors assume risks that in many cases are not readily apparent. From a public policy standpoint, I don't know if that should be a basis in this case for permitting the doctrine to continue, because the legislature did not carve out any exceptions with respect to that, and it had the opportunity to do so.
Could there be a concern by the public that if you got rid of assumption of risk, there would be no more sports for kids to participate in?
Well-
Because it would be a crushing financial obligation to insure?
Well, I don't, Your Honor, I'm not sure that really the sky is falling attitude toward what might happen if we just retreat, if you will, to ordinary negligence standards is realistic. I think that in most cases, when we would look at the activity, and let's look at the activity in this case, it refers to baseball. In traditional baseball game, if you had kids participating even at the high school level, they took the field was properly groomed, there were no things.
So let's look at this case. And the question being asked, is there a risk that was greater than the athlete assumed here by participating in the drill in the manner in which it was constructed, such that there's at least a question of fact that should allow the case to go forward?
Well, in this case in particular, Your Honor, that's our position. We think that there were many questions of fact as to whether the doctrine should apply in this case because, as you pointed out, one of our arguments is that the risk was unnecessarily increased.
Why? Isn't there many balls in play in a baseball practice? Isn't that a risk that you assume? Like, isn't that something that's standard? Are you suggesting that the only way that you practice for baseball is with one ball?
No, but this is actually coupled with more than just the multiple ball drill, right? In this case, there was also a screen that was purportedly placed out there that was as Judge Pritzker said, was placed out there and it was operationally defective, right? It was not a device that could have protected the student in this case from the injury that he suffered.
Yeah, but short of the student being in a bubble, I mean, what screen would? It wasn't an opaque screen. There wasn't a hole in the screen.
Well, the screen could have been, in this case, it could have been larger than it was. It could have been properly selected. It could have been
But
tested
isn't that an
beforehand
obvious
and measured.
risk, counsel? I mean, the screen is what they were using, 7x7, I think?
Yeah.
So this player goes out, there's a 7x7 screen between these two players in the infield, and they can see that. I mean, it isn't where you sit behind netting in a baseball game, there's a hole in the netting and the ball comes through that you wouldn't be expecting. I mean, this is a limited protective device that's out there.
But, Your Honor, I don't think, if we take a step back and we look at whether the risk is inherent in the sport, right? And then the activity that is, in this case, the practice, it has to relate to the risk that is generally inherent in the sport for the doctrine to apply. If, in this case, we would have been talking about the first baseman who received the throw from the third baseman, and he missed the ball and it hit him in the face during routine ground ball drills, there'd be no question, there'd be no negligence there. Going to Your Honor's question before about whether the floodgates would open up with respect to unlimited liability in the game. I think that at the trial level, at a minimum, the court would dismiss the case after summary judgment because there would be no indication that the parties acted unreasonably. In this case, as you look at the drill that was being conducted, not only were there multiple balls being hit and put in play throughout the infield, there were multiple players at each position, and there were, in this case, there was a screen that it was imperceptible that this screen was defective in the sense that it could not protect the player at first base and the players behind him that were getting ready to take their position at first base.
So going back to a question Judge Wilson asked you, if you take all those factors and you try to distill it into a rule that, pulls back what you say is the creeping expansion of primary assumption of the risk, what would be the articulation of that rule? Because we can't have a rule that says, when you have 10 baseballs and one screen, we need something a little more applicable to the rest of the world. What would it be?
Well, I think, as I said, our position is we think that the doctrine itself should not stand.
Granted, let's assume for 1 second that it's not going to be a wholesale overruling primary assumption of the risk. What's the correct limitation on that doctrine?
Well, Judge Wilson's point, I think, was that when Turcotte was first decided, that really applied to professional athletes. I mean, I think that's
Let's take the
probably...
example you just gave, though, where it's a high school baseball player and there's no multiple balls or anything like that. It's a routine play. The first baseman simply misses the ball and hits him in the face. It seems to me the consequence of eliminating primary assumption of risk doctrine in that circumstance is just what you said. This goes all the way through summary judgment, whereas if we have it in place, the case would probably either not be filed or would end at a motion to dismiss. And so that is sort of the question, I guess, right? Is if it is, do we want to protect even that or not?
Well, I think, Your Honor, I mean, not to state the obvious, I mean, that's what the courts are for, right? And I think that if litigants think that they have a case and they have a right to bring it, they should. What the courts will be the gatekeeper eventually, or ultimately, as to whether or not those cases should go forward or be dismissed summarily at some earlier stage before it goes to trial.
Let me ask a different question, which perhaps is somewhat of a bridge between these two inquiries that my colleagues to my left and right are making. So let's just be clear on what this pulled back closer to Turquette rule would be. Is it that you focus on the inherent risks of the sport as it is played? This is a little bit of, I think, of what Judge Singas was getting to. Or the inherent risks of the drills that are associated with that sport?
Well, I think the drill that is conducted in order to make a determination whether that is, it is not inherent in the sport or it imposes risks that are not inherent in the sport.
Right.
The drill itself should relate very closely to the actual game, right? And so in my example where we talked about ground balls being hit to the third baseman and the third baseman fielding the balls and throwing them over the first, that's very similar to game time activity. Once you start increasing the risk, increasing the number of players on the field, injecting supposed security devices, multiple coaches on the field hitting balls or throwing balls where balls are being thrown in the same direction, now you're starting to move away what is traditional in the sport.
But that sounds almost unworkable, right? You're sort of saying, well, there are some drills that are okay and some drills that are not, and it sounds a little bit unclear where one would draw the line between the drills that are acceptable and the drills that are not, or at least the drills that open up the defendants to liability, let me put it that way.
Well, Your Honor, you're correct, and that is one of the issues that we're faced here in this case and in the cases that have to examine whether primary assumption of risk applies. We think in many cases it's outcome determinative. It's really, sometimes, I don't want to say it's a crapshoot, but sometimes you really, there's not a good
But to
body.
be clear, you're not taking the position that one only looks at the way the sport itself is played. That a drill might still fall within the existing framework.
That is correct.
Okay.
That is correct.
Okay.
In this case, as we've pointed out and as the two dissents have pointed out in the third department, this was very different than the ordinary sport. And that once you couple the activity of the number of players, the number of balls being hit, the activity that they were conducting, and a screen, that the risk associated with it was imperceptible, even to the coaches.
Let's say they had no screen.
Well, that I think makes it much easier, Your Honor. I think if there was no screen and the player was struck, the argument would be that the primary assumption of risk could not apply because the activity was so inherently risky.
So the screen here doesn't make a difference, really, then? I mean, whatever screen they had, I mean, no screen, any screen, because there's no screen that's going to protect a player completely. So if the player's hit, in your reasoning, I mean, that's a defective screen, so the screen to me seems unimportant in this
Well,
case.
the only reason why we focus on the screen and the activity combined, and I think that the Judge Pritzker did as well, is because one of the things that you look at in analyzing whether there is no duty on the part of the defendant is whether there's an assumed risk, whether there's a concealed risk, or whether the risk has been increased beyond reasonableness. And so in your example, we would make an argument that because the risk was increased unreasonably, the defendant would not get the benefit of the no-duty rule, and therefore the primary assumption of risk doctrine
If it was a big
would
enough
not.
screen, the risk would not be increased to the level you say?
Well, I think that it would be a couple of things. First, big enough screen, and then also that the drill would have to be conducted safely.
But let's say this drill,
This,
big enough screen would do it or not?
well, if there was a determination made that the screen was adequate to protect the player, and there are screens that would have been adequate to protect the player. The screen could have been larger, one. The screen also could have been situated at a position
Player
where...
gets hit, then it obviously wasn't large enough to protect the player, right?
Well, that's one of the points that we make in the case. There's the safety equipment chosen in this case, which then falls into a very different line of cases, which say you can't have a primary assumption of risk doctrine and a no-duty rule applied if the equipment is defective. And as Judge Pritzker pointed out, it was operationally defective in this case because the screen was not positioned or of a size that it was adequate to protect the player. Now, there could have been screens that would have been adequate.
The other way to look at that, Othinko, is it provided a certain level of protection, 7 by 7 foot protection, which is obvious when you step out on the field, just as no screen would provide no protection, obviously, for that in that way. And that's what you assumed. I mean, you walk down the field, there's the screen, you see what it provides, or there's no screen and you see there's no screen. You play, you assume.
Well, I would say to that, Your Honor, here you have a high school student that's looking at a screen that's 7 foot tall, obviously taller than he is, and he's assuming, just like the coaches were, that it was safe and it was adequate. But in this case, we know it wasn't. It didn't work.
But he knew that too, because there was testimony that he knew that somebody was hit, so.
Well, you know,
right?
Your Honor, I need to try to put that to rest. That whole argument that's in the defendant's briefing and was also argued below is just incorrect. As the dissents have pointed out, there was no testimony that prior balls had bypassed the screen. There was no testimony as to where the prior baseballs had come from that were errantly thrown. There was no testimony as to the one player that it had been indicated was struck in the leg where that ball came from. And so on all of those issues, while there were balls being thrown around, and no one doubts that that doesn't happen in a traditional practice, there's no testimony that any of those balls bypassed the screen so as to put our client on notice that that screen wouldn't have protected him. And with respect to Judge Garcia's question as to the size of the screen and wouldn't the player have been able to determine stepping onto the field that would or could have protected him, I would say as to that, once you get onto the field and you start taking these throws and ground balls, because of the way that the balls are going to be, you're going to have to react to them. They're going to put you in a position where the screen might not be in a position to safely protect you. And so if it's too small in this case, or it's positioned in a manner that it shouldn't be in terms of the distance from the fielder, then the coaches should have made adjustments to that.
So is it the screen or the manner in which the drill was conducted
It's
by
actually-
the coaches?
It's both. It's both.
Thank you, Mr. O'Hare.
Thank you.
Good afternoon, Your Honors. If it pleases the court, my name is Giancarlo Facciaponte on behalf of Respondent Chenango Valley Central School District. Initially, I must put something to rest of my own. In the transcript of plaintiff's testimony during the 50H examination, the record at page, I believe, 123 to 125, plaintiff discusses his feelings on the protective screen and the level of protection it provided. I think calling it a protective screen is a misnomer because plaintiff himself says that he does not believe it provided him any protection. He believes the drill was dangerous. He believed that the screen was not something that was there to protect him from balls. If you look then at the testimony of the coaches as well as the plaintiff, I think it's clear that the screen at most provided protection to guide the drill and the catch between the players. Now, as I noted in my brief, I am not a baseball man.
What about the argument that it is likewise the manner in which the drill was conducted by the coaches?
Yes. To that argument, I think it's very important to realize Now that we take the screen out of relevancy of the situation, and there isn't anything to indicate that it is relevant to the situation, what we are left with are students playing catch and hitting balls in baseball practice in the middle of a field. I do not
So it
see how
doesn't
that is
matter
very different
that
than
they're-
the long line of cases.
Doesn't matter
rule
that
on
they're
the issue.
coming at a player from different directions.
No, Judge, it does not. As I noted, I'm not a baseball man. I played lacrosse, but I did have occasion to see a lot of baseball practices. And in those baseball practices, I think that we all know, driving by fields, you can see kids running all over the field, playing catch, multiple balls, multiple people, running back and forth, doing multiple things at multiple times. There is no one set environment in which these practices occur
So
throughout the state.
is there, in your view, there is no version of a drill that would render your clients liable?
Of course there is.
Okay, give me an
Judge.
example.
An example would be any drill
You've seen a
that,
lot of baseball. Give me an example.
any drill that unreasonably increases the risk of safety. I will point to a case, Murphy, I believe.
What's unreasonable? Because I assume you think that
Sure.
this was a reasonable drill.
Judge, it would be, for example, unreasonable if you asked a experienced baseball player to stand too close to the plate intentionally and get hit with a ball. That would be unreasonable.
Well, wasn't the purpose of this drill to have players from different areas of the field throw balls at the first base player?
I gather that to be the case, yes,
And
Judge.
that would mean that the balls are coming in from different directions. So when I'm looking over here at the ball that's coming from that direction, there could very well be another one coming in from the place that I'm not looking.
That I would not agree with, Judge. I believe that there is testimony that the timing was supposed to be such that there would not be, obviously, two balls thrown at the same person at the same time.
Can you depend on a bunch of kids? And I think there was some testimony that some of the players in this particular practice on this day were not varsity level players, they were junior players. Can you really depend on kids to make sure that the balls are only coming one at a time?
I
from
believe you
different
can
directions?
depend on them exactly to the same extent as you can depend on them to not get hit in the face with a ball as they run across the field while multiple people are playing catch.
Isn't there testimony from Coach Allen that he told the players the screen would protect them?
I believe there is some testimony. I'm not sure if the word protect was used verbatim. But once again, I believe if you look at that testimony in combination with plaintiff's testimony and the structure of the drill itself, the screens provided a focus guide, much like pylons in football or lacrosse. So those pylons aren't going to stop you from running into someone should you err, but they provide you a guide so you don't err in your task if you maintain your
Was there
focus.
expert testimony as to whether the screens were an adequate protective device?
There was expert testimony submitted from both sides, but it did
On
not,
that question, on whether the screens were a protective device, no?
not based on scientific data.
Oh, I didn't mean that. I mean, that's just the value of the testimony. I'm asking about what they said.
I believe plaintiff did submit a baseball expert of some sort, and he was paid to proffer an affidavit based on the record, and
And the defendants
he
had
felt
an
it
expert?
was unsafe, and I believe we proffered an affidavit as well, and equally, they were both not considered by the court because they were not based on scientific data,
I think
which,
the question is, despite the argument now, did not your clients argue at some point below that indeed it was an adequate protective device?
I believe that the coaches use the word protective or
They're the ones
describe
choosing the
protective
screen,
circumstances.
so it must be what they think they're doing with the screen.
Right, and I don't think that's inconsistent with the facts, Judge, because as I described, they provided a focus aid to the students so they wouldn't err in their drill.
Let's
What
go
this
back
case
to your
hinges on-
example. In baseball, humbly, I'm not an expert on baseball, but as I understand, there are many times when a player gets very close to the plate.
Yes,
So
sir.
I'm not really sure, if I understood your example was that would be unreasonable.
In Murphy versus Polytechnic, it was, Judge.
But I'm asking you, how is that not like the sport itself?
Because
Not inherent to a risk in the sport
your
itself?
coach does not ask you to violate rules normally in the sport itself.
No, I'm talking about your example. I'm sorry, maybe I misunderstood your example.
Yeah,
What was
that
your
is
example?
the example, Judge. In Murphy versus Polytechnic Institute, a student was asked to stand too close to a base. I believe she was hit with a bat at that time that was swung by the coach. She was an experienced player. just like the plaintiff was experienced here. However, there it did not turn in her favor, or there it did turn in her favor, here it does not. That experience let her understand that she should not have been doing this, and therefore she would not think her coach would ask her to stand somewhere that he was going to physically hit her with a baseball bat because he's an adult and a coach. He did. So obviously that is not a foreseeable risk. Here, we have plenty of testimony from the plaintiff about
So
his
if the coach
experience.
just designates a bunch of kids to throw around balls that might hit you, that is the distinction? One is the coach is hitting you with the bat?
I believe
The
that,
coach sets up a risky situation where you get hit with the balls?
I believe that a coach designating a bunch of kids to throw around baseballs is a baseball practice, Judge. That is what they do there. So,
Mr.
you know,
Facciaponte, can I ask you a policy question?
Yes, of course.
You can correct me on any of these premises, but my understanding of the current primary assumption of risk doctrine, the bases that it relies on, is that sports, and I'm going to say even school, school sports, have an enormous societal value. There's a utility to them. It gives kids a chance to play on a team. It teaches them good sportsmanship. It teaches them to follow the rules. And all of that has led to a sort of carve-out to 1411 for these kinds of activities.
absolutely, Judge.
Great. So now my question is this. When you put people in a scenario like the one you have here, where you're actually taking it, you're creating a practice and you're saying the rules that you need to abide by when you play the game, which we find have great social utility, don't apply here. You could have multiple balls flying around, and that's the whole point. Everyone's going to throw balls at the first baseman. What is the social utility in that calls for this court's protection?
Judge, first and foremost, the social utility has to hone in on what exactly these kids are doing here, okay? To understand the social utility, we need to understand what exactly these kids are doing. And these kids are intentionally disregarding the normal due care of their body
They've
to
been
perform
told-
feats of strength.
They've been told to break the rules of the game. And I'm saying one of the benefits of organized sports in schools is that you learn to play by the rules, and that's why we protect it. That lesson's not being taught in a practice.
Judge,
where
I'm
the rules
talking
are
more
broken.
basic than that. At practice, these children want to get better. They want to use their bodies to get better, and they are disregarding the normal due care of their bodies in order to do so. At any point in time, they can leave. They can walk
let
off
me
the
ask,
field, and plaintiff here knew that. He didn't.
Suppose the coaches had moved the pitching mound from 60 feet inches to 30 feet, and told them, and the kids want to improve their bodies and whatever, and the coaches said, this is going to improve your reaction time, because now you're going to have half as long to respond to these pitches. Is that protected?
I think that
They're
is
still
a
throwing
much
balls
closer
around.
question than the
Well,
facts
but
at bar here.
They fit all of the answers you've given. They're still doing things, they're still throwing the ball around, they still want to improve their bodies. I don't understand how to distinguish that from this.
Judge, because you have to look at the totality of the circumstances. Here, we have no, Your Honor, once again, now maybe I don't know enough about baseball, but I believe that would still have some utility and value, yes, much like Burkowski. That is much more like the situation in Burkowski.
We
which
already have,
primary
we already
assumption
have a
was applied.
case saying it doesn't apply when you move it to 45 feet.
Once again, one thing I would actually like to avoid and note that this rule as it currently exists, and I think that what plaintiff is essentially arguing at the end of the day is really just proper application of the primary assumption of risk doctrine. This rule as it currently exists requires no exacerbation of the foreseeable risks known to the students, okay?
Is that a rule you can live with?
Absolutely. I think that is the rule now, and that's the rule as it should be, and that should be the rule in the future, and that should be the rule adhered to, but we can't miss the forest for the trees and start basically trying to, in an effort to get rid of what plaintiff refers to as a judicially created doctrine, and I would argue it's a common sense created doctrine going back thousands of years, we can't create
Yeah, but
another judicial
Can the doctrine really withstand scrutiny when it's not what the legislature intended? It's fine if the legislature has not itself expressly spoken.
I contend that the legislature has spoken, and this is what they intended, because when they enacted 1411, they knew of express assumption of risk. It is a comparative fault statute schema. Comparative fault compares blameworthy actions under the law. It is not a passport to file
Doesn't-
an action for negligence.
I'm sorry, doesn't 1411 actually mention assumption of the risk and say that it is now going to be subject to comparative fault?
By word, and specifically because at the time, to enact implied assumption of risk as a defense, you would have to compare fault. That removes that gambit. As Turcotte in the line of decisions continuing on discussed, this is a no-duty rule. This is different. We're not talking about a situation where there's an action at fault. We're talking about a situation where kids decided to voluntarily
Okay,
engage in something
I'm sorry,
with their
I'm just
bodies.
trying to understand your statement that this is actually what the legislature intended when they wrote 1411. You're saying they intended for the courts to maintain a primary assumption of risk doctrine?
Yes, if we look back to Abergast, it talks a little bit about this. We could, legislative intent cuts both ways. When a legislator does act, you can then assume that they knew of the existing case law and statutes at the time. And then if they do not act further in the face of the evolution of the law, you can assume that they are aware of that as well. And because they took actions in the past, they know of what actions they could take at present. The case law here that is relevantly being applied has existed for almost 45 years now. The legislator could have done exactly what it did in 1975 if it wanted to get rid of primary assumption of risk. They have not done so, and I believe they have not done so for a reason. And the reason is because should that be extinguished, what is the alternative? As we discussed, are we going to put children in bubbles? Are we going to legislate exactly how big the screen should be, from the bench or from anywhere else? I think that's all too far. I don't think anyone wants that for their children in this state or anywhere else. I think we want our children to be able to play sports and be able to walk off the field.
There are
if they
other
think it's too
jurisdictions
dangerous.
that don't have this kind of exception, and seems their sports do fine.
Well, Judge, I don't live in them, and I can't really speak to them, but I'm not sure if anyone, would curtail the principles behind New York's primary assumption of risk doctrine in the way being requested by the plaintiff in this case. I think that the facts at bar here, at least in the Grady matter, fall squarely within that logical gambit of why we have this doctrine in the first place. I'm voluntarily putting my body out there. I know I can withdraw it at any time. I recognize the risk. I testify to that. I allege it in my complaint, and I decide to do it anyway. I can't claim I'm wrong by an injury that is a natural result of it.
Thank you, counsel.
Thank you, Judge.